Well, the big story from the court corner, the Supreme Court has said that the technical committee probing allegations of unauthorized use of Israel's NSO group software Pegasus has found malware in 5 of the 29 phones examined. However, the court has said it was inconclusive if the malware was Pegasus. The court has also expressed its disappointment with the union government for not cooperating with the investigation or clarifying whether Pegasus was used or deployed. CNBC TV18's Ashmit Kumar joins us now with the details. So, Ashmit, on one hand, the Supreme Court's technical committee saying it has no conclusive evidence to suggest that Pegasus was used. On the other hand, it's also saying that the government didn't cooperate or clarify on the use of the Israeli spyware.
Well, let's keep in mind that the Apex Court had appointed a 3-member technical committee which was headed by Justice Ravindran, and that is the report that in fact was read out in open court for the first time by the Apex Court. Now, what's critical here are the takeaways. There are 3 key takeaways here. Number one, as far as the centre's conduct is concerned, the Supreme Court expressed disappointment, in fact cited observations that were made by the technical committee that the centre did not cooperate. The technical committee's position was that the centre continued to be evasive and did not clarify whether or not the Pegasus software was procured or deployed on the citizens of the country. That's the first takeaway. The second, of course, is the technical committee and its own findings. The report has not been made public yet, but there are some aspects that were read out by the Apex Court. From that, the technical committee clarified that of the 29 devices that were subjected to forensic investigation, there were malware found in 5. However, the technical committee said that it could not be said conclusively that the 5 instances of malware was in fact Pegasus. So that in fact has been an important clarification. Technical committee holding that this could possibly be, the malware could possibly be due to lack of cyber hygiene. The third takeaway is Justice Ravindran's comment. Justice Ravindran very clearly pointed out that there is definitely a need felt for strengthening surveillance laws, and also at the same breath has recommended as a part of his report that there is also a need for strengthening individual privacy, citizens' privacy. So these are some of the broad takeaways yet coming from the open court hearing. We'll, of course, yet to get a copy of those 2 reports that were submitted before the top court. Back to you.
Well, this was only one of the many cases that were heard in the Supreme Court. In fact, the Chief Justice taking up these matters today on what is his second last day in the court. So, Ashmit, let's talk about some of the other matters that were taken up today. The court has also made important decisions regarding the Prevention of Money Laundering Act. It is said that while the objective of the act is noble, in its words, 2 aspects of the earlier judgment upholding the act do need to be re-examined. Take us through which aspects these are and what happens next.
Well, Justice Khanwilkar-led bench of the Supreme Court had come out with its judgment on PMLA, whereby various provisions of the PMLA which give sweeping powers to the Enforcement Directorate were in fact upheld. Justice Khanwilkar in fact was subjected to heavy criticism, and then finally we saw a review petition being filed in the Supreme Court. What's interesting is that the Supreme Court, the CJI-led bench of the Supreme Court very clearly held that prima facie there are anomalies with that judgment. Prima facie there are some aspects that the Supreme Court, that the CJI-led bench is not comfortable with, and prima facie the Supreme Court has expressed its intent to go ahead and to reconsider some of these aspects. The centre, of course, came out all guns blazing, said that this is tantamount to appealing a Supreme Court order under the garb of a review. The centre also said that there are international covenants that India needs to respect by way of the PMLA provisions, and diluting those provisions will mean that India would be in breach of those covenants. But nonetheless, the Supreme Court taking a very stern view that there are 2 particular aspects of Supreme Court red flag. Number one is non-provision of the ECIR. In some cases, the ED is not bound to make the copy of the ECIR available to the accused. This is the first thing that the Apex Court has taken objection to prima facie. The second is the burden of proof. Normally, under normal criminal procedure, the burden of the proof lies on the state. The state has to prove that the accused person is in fact guilty. It is the other way around as far as the PMLA is concerned, where the burden of proof is on the accused. The accused is the one responsible for proving his innocence. This is a departure from criminal provisions here in the country, and that is the second aspect that the Apex Court in fact has taken objection to prima facie and said that there is definitely room for a review. And on that note, a notice has been issued. The centre has been asked to come back with its reply on these initial prima facie observations made by the top court. Back to you.
Ashmit, many thanks. And we are going to be discussing the importance and the significance of this review in just a short while from now. But another important matter that was taken up by the Supreme Court today, the Supreme Court has issued notice to the Gujarat government on a plea against remission granted to 11 convicts in the Bilkis Bano gang rape case. The bench led by Chief Justice N.V. Ramana has sought the state government's reply on the plea within 2 weeks. The court has also instructed for the convicts to be impleaded in this case. Meanwhile, the Delhi High Court has refused to stay the Agnipath scheme for recruitment in the armed forces. The court has asked the centre to file a reply on a batch of petitions challenging this scheme. And the Delhi High Court has also rejected Facebook and WhatsApp's appeals challenging a CCI order, calling for a probe into the messaging app's new privacy policy, observing that their plea has no merit. This order paves the way for the CCI to proceed with its investigation against the social media companies for possible abuse of dominant position. The court has asked the companies to approach the competition regulator for any relief on the matter. Well, a slew of hearings, both in the Apex Court as well as the Delhi High Court today, and these will have significant implications, a big day in court. Joining us now to discuss some of these issues, Karnal Singh, the former Chief of Enforcement Directorate, Sanjay Hegde, the Senior Supreme Court Advocate with us, and Siddhartha Datta, Partner of the Dispute Resolution Division at Shardul Amarchand Mangaldas. Gentlemen, appreciate you joining us here on the program. Sanjay Hegde, let me come to you first. The Supreme Court taking up the plea on the PMLA matter today and saying very clearly that it will review, but it will review on two of the crucial aspects that have been bones of contention. One, providing the ECR before arrest, which the 27 July verdict has said was not mandatory. That is going to be up for review. And the second issue from the 27th of July Supreme Court verdict, which is up for review, is that the accused person has the burden to prove his innocence, which is now going to be looked into by the Supreme Court. On balance, while it is not a full review, how significant is today's day when it comes to the PMLA matter?
It's a very significant day because normally review petitions are heard and dismissed from the chambers of the judges. Yesterday, when they issued notice for an oral hearing, it was clear that they had certain doubts about the judgment of the three-judge bench. And you must note that two of those judges continue on this bench. So the Supreme Court issuing notice and prima facie telling the government, look, these are the problems that we have at the moment. It may be that there will be other problems also. Now, just let me explain for your viewers what these two problems are. One is the reverse burden of proof. You are normally presumed innocent until you are proven guilty. Here, in these cases, they say, no, we presume you to be guilty. Now you go prove your innocence. That's like asking you that classic question, have you stopped beating your wife? Now, how do you say that, no, I don't beat her at all? And how do you prove it? So this is one aspect of the problem. The other aspect of the problem is if you don't give the accused a copy of the complaint, or the ECIR in this case, how is he to know what case he has to answer? All that he knows is that the ED has just taken him into custody, and then he has to apply for bail. He does not even, if he does not even know what case he has to answer, how is that fair? The more I look at this law, the more I'm convinced that it tends to make India look like a police state. The sooner that either the court reads it down or the legislature waters it down, the better it is for all concerned.
You know, Siddhartha, let me just take what Sanjay Hegde mentioned forward. These are two of the contentious aspects that the Supreme Court has decided to take up as part of this review. There were other contentious issues as well that were raised by petitioners, whether it was when it comes to the seizure of financial assets before the trial, or the seizure of assets that were not connected with the offence, or in fact the conditionalities attached to possible bail and low chances of getting a bail. Now, all of that we don't know if at all it will be addressed by the Supreme Court as part of this review in any form or fashion. The court today has said it's restricting itself to these specific aspects. But what do you make of what has come from the court today and the next steps?
Well, if you look at the PMLA judgment as was passed earlier and which is going to get reviewed partially, if you look at certain parts of the judgment, it seems to contradict other parts of the judgment. For instance, the judgment very clearly says that the process of the ED should not be on a notional basis. It should not be based on assumptions. There should be proceeds of crime in existence, and then only the enforcement directorate can take action. But on the other hand, if the accused is not informed of what are the grounds to say that it is relatable or that it is linked to any kind of criminal activity, how does the accused ever will get a chance to defend itself? Now, there are parts of the same judgment where actually they say that the ECIR need not be given to the accused. It says that the grounds for arrest needs to be informed. Question is how? How will the grounds of arrest be informed? There has to be a document, there has to be a basis to inform it. So I think the whole judgment needs to be looked at, even though it is one aspect which has been spoken of today, but the whole judgment can be looked at to see consistency of the legal principles which have been discussed.
You know, some of those anomalies that both Sanjay Hegde and Siddhartha Datta are talking about, Mr. Karnal Singh, let me come to you now with this, because the centre's argument in court, including today, was that this should not be up for review, that a review would in fact ensure that this would be a contravention of international covenants, that this will have serious implications and severe repercussions. What could be the severe and serious repercussions? Isn't it fair, Mr. Singh, that, you know, if you're accusing somebody of a crime, that the copy of the ECIR is actually given to the accused? Why should the burden of proving innocence be left with the accused and not on the state to prove guilt to start with?
See, let's understand first the section 24, which is we people call reverse burden of proof. Now, the question is the Prevention of Money Laundering Act comes into play only when there is a predicate offense. That means the person is already has an FIR of some other offense. Say, for example, a case of cheating, bank fraud case. He has a copy of the FIR with him. He knows that what are the allegations against him. The PMLA talks of whatever the person has got proceeds of crime from that offense. Now, those proceeds of crime, how he is doing the laundering of that. And therefore, what this section 24 says, if some person has proceeds of crime, which is the burden of proof of the prosecution. Prosecution has to prove that this person has got the proceeds of crime. Then whatever property is attached from that person, in that case, that person has to say that this property has not come out with those proceeds of crime which is already with him. So that it is a reverse burden of proof comes not totally. It is not that somebody has to prove his innocence. The first thing is already there. The prosecution has to prove he has got the proceeds of crime. And only then the burden shifts to the other person. Now I come to the ECIR. See what happens in the non-cognizable offense where police agencies register case. The section 154 of CRPC says that the FIR is to be registered. First information report is to be registered. And there is a supervision of the court. FIR is immediately sent to the court within 24 hours. That is a procedure in the criminal offenses. Now, in the case of money laundering, PMLA, there is no provision of filing any FIR or any ECIR. So what this ECIR has come out of this, see what could have happened is any officer could have started any case without the knowledge of even the headquarters. So there are internal circulars which says that if you want to investigate any case under PMLA, you have to record and a numbering is to be given. So it is an internal document and it has nothing to do with like similarly FIR. Now in case if somebody is arrested, for example, the person already knows about the predicate offense, that is number one. Number two, court, the grounds of arrests are given. And number three, court can always call the whole file before granting the bail or not granting the bail. So there are procedures available in this act, and that is what the Supreme Court has said in its judgment.
Right. Sanjay Hegde and Mr. Datta, let me get you to respond to what we've heard there from the former ED chief, saying that there are enough checks and balances already in place, and hence he doesn't believe that there's anything wrong with the fact that an ECIR is not shared, or the fact that, in his words, you know, there is already guilt established, and so it is now up to the accused to try and prove that they're not guilty. Sanjay Hegde.
Well, somebody said that power is delightful, and absolute power is absolutely delightful. Quite true. You know, the finance ministry officials can say, oh, there is a case, you know that there is a case of cheating. Then forget it, whatever is that case, whether you succeed in the trial or not. We are going to launch a ED case. We will say that all your properties happen to have come out of that one particular part of cheating. We are going to arrest you and then let you stew in jail till such time as the judge comes to a conclusion after hearing the public prosecutor that you may likely not have committed the offense, and that if you are released on jail, you may likely not commit another offense. So with all those ifs and buts, where the process becomes the punishment, and being handed over directly to the officials of the finance ministry, I do not think that the constitutional guarantees of a just and fair procedure before your liberty is taken away, which is provided to every citizen under Article 21 of the Constitution, is satisfied. This is exactly what a police state looks like, and power is given not even into the hands of policemen who have at least some kind of training in law. It is straight on to one department of the finance ministry. And we speak of all these international conventions. What are you equally are subject to international conventions on human rights, aren't you? Secondly, the international conventions concern only the offenses of drug trafficking and arms and terrorism. You go on to include each and everything under the schedule to the PMLA. So, an ordinary cheating case, somebody cheats somebody else in some business, has a few lakhs. The fellow happens to have a house worth crores. You attach that house. The point is that you have made an overbroad, over-harsh law, and you can use it selectively.
Overbroad, over-harsh law. I'll get Mr. Karnal Singh to respond to that in just a second. But Siddhartha Datta, respond to what we heard there from the former ED chief, and then I'll get him to rebut.
There are 2 points here. The first thing is that if we look at the August 23rd judgment of the Supreme Court, which is also very important, on the Benami Transactions Act, there are 2 paragraphs which talks about the PMLA. And it talks about how the actions of the ED should be proportional. It is a very harsh powers which they have at their discretion, and therefore there should be proportionality as far as their actions is concerned. Now, supposing, let's say, that a court has to examine as to whether the act is proportional, whether the act of the ED in making certain attachments or freezing orders is actually tested. How would that be tested if the ECIR does not make out a case for such action? So if the PMLA judgment, which is subject of review, there are certain parts which say that the PMLA is an independent court. Now, if it's an independent court, then the ED cannot rely on any other finding of any other court with regard to its actions. So therefore, there has to be justification and a record of the justification for its actions, and that can only be on the basis of an ECIR. Otherwise, the rights of the accused would be severely hampered. That would be my view. So you have to take a holistic view of it. It's not only a question of giving a copy of the ECIR. It's the justification for actions which follow the recording of an ECIR by the ED.
Absolutely. And Mr. Singh, let me get you to respond to that. One, of course, is the larger issue of proportionality, which has not just been raised as a concern here by Sanjay Hegde and Siddhartha Datta, but has been raised as a concern since the time that we saw that Supreme Court verdict coming in on the 27th of July. And that matter has in many ways found its way into the hearing in court today. And the other is this issue of the process itself becoming the punishment, and respond to the specific aspects raised by both Sanjay Hegde and Siddhartha Datta. Should there not be be the test of proportionality, an overbroad and over harsh law, is that really the best for us to move forward with?
See, let me touch upon first about the International Convention and the FATF, Financial Action Task Force. It is not that the FATF talks about only 3 types of offenses. It gives a list of all types of offenses, and we have included in the Schedules of Prevention of Money Laundering Act only those offenses which have been mentioned in the FATF guidelines. That is number 1. Number 2, I agree with the proportionality. And for that, there are courts. When the case goes to the court, they can examine, they can see. Mr. Hegde was basically talking of Section 45 PMLA. Of course, that is under review also. So I'll not comment on that, what happens to the Section 45. But what you have to understand is the impact of prevention of money laundering. If somebody is doing the money laundering, it does not impact him only. It impacts the society. It impacts the law-abiding citizens of the country. It impacts the whole fabric of the country where the system becomes corrupt if the money laundering is allowed to take place. So the implications are far serious if the money laundering is allowed in the country.
Well, yes, I don't think anyone is suggesting that money laundering should be allowed in the country. I think the larger question is a question of proportionality and also guaranteeing and protecting the rights of the citizens of this country. I think that's where this debate is currently at, and this is going to be something that the Supreme Court, at least on these 2 specific aspects, it's already said it will look into. But whether or not other important aspects that have been discussed here today and have been raised by others, including the petitioners, will be taken up, we will wait to see. Mr. Singh, Sanjay Hegde, Siddhartha Datta, a pleasure. Thanks very much for joining us here today on the Court Corner on CNBC TV18. Appreciate your time. We'll take a break. There's a lot more coming up. Don't go anywhere. We're back in a minute with more.